You can sit and ask. No need to stand up.
Sure, sir?
Yes, I am sure, fully sure.
Dr. Kotwal, glad to hear you and like to talk to you. This has been very enriching about the terms of the constitution.
Ji.
Sir, my question I have already written out about the reservation. I was misinformed about the reservation part. As you mentioned in the conversation that there are three kinds of reservation.
Yes.
Political reservation.
Yes.
And public job reservation. And third I forgot. So, sir,
Education institutions.
Yes. So far as the abolishment of the reservation category is concerned, who has the power to abolish this reservation category?
State, government of the day. Easiest answer.
Okay, sir. So, like, to appeal, like, as you mentioned about the state, every state has a power to abolish the reservation.
State in a broader sense, state government as well as union government,
Okay, sir.
as per Article 12 of the Constitution.
So, as a citizen, if you want to appeal to the government, whether it's a state government or a central government, what is the way for that, sir?
For that, we need to understand the provisions for reservation in a bit deep manner, and that would take at least 5 to 6 hours for me to teach you. But still, I would give you a rough idea. You have to go through clauses 4, 5, 6 of Article 15 and 4, 4A, 4B and 6 of Article 16. Article 15 has 3 clauses. One is 4, 5 and then recently added through 103rd Amendment, that is 6th clause. And in 16th article, there are 4 clauses that we need to go through. One is 4, the other is 4A, added through 77th Amendment. Then there is 4B, that was added through 81st Amendment. Through 85th Amendment, one more thing was added in 4A, that too is very important from reservation perspective. And lastly, through 103rd Amendment, clause 6 was added in Article 16.
Sir, what if someone is filing the petition in the Supreme Court?
Yes.
Supreme Court take this like
Yes, yes, there I will reach. If you read these clauses, it specifically says that, for an example, Article 15, the language has been phrased in such a fashion that state shall have the authority to provide for any special facility, any special arrangement for the weaker sections of the society. State, here for a layman, we shall consider it to be government. Let it be any government, union government or state government. It says that government shall have the authority, it shall have the power to provide for special treatment, special facility for the weaker sections of the society. Let me tell you, this was not even written in the original constitution. It was added through the First Amendment Act of 1951 in response to Champakam Dorairajan case of 1950. My point is, original constitution in Article 15 nowhere provided for reservation in educational institutions. Nowhere it provided. It only said in Article 15 Clause 3 that state shall have the power to provide for special facility to the women and children, not to any weaker section, not to any weaker section based upon caste. Not to any weaker section based upon the caste or religion. It only said that state shall have the authority to provide for special facility for women and children. But what happened was, there was a famous case of Champakam Dorairajan case where communal order of Madras state government of that day was challenged, which provided for reservation to all categories, be that Brahmins, non-Brahmins, Muslims, everyone. So that order was challenged before the Supreme Court, and it was claimed that this order of reservation violates my fundamental right under Article 15, where it has been said that I cannot be discriminated upon by the state on the grounds of caste only. So it was challenged before the Supreme Court. Supreme Court said that you cannot provide for the reservation on the basis of caste. This was the judgment of Supreme Court in Champakam Dorairajan case. But as 1950 or 51, yes, Champakam Dorairajan case. But the situation of that time was that state, the government knew that there are almost 70% sections of Indian society, Indian population that are highly backward, socially backward, educationally backward. If we do not provide for reservation for them in the education institutions, they are not going to be uplifted if you have read about the Kalerkar Commission report of 1950s, in that report, Kalerkarji, Kaka Saheb Kalerkarji, Savai Gujarati, he specifically said that apart from SCs and STs, there is 32% of Indian population that is backward. SCs and STs are already backward, that form around 20 to 25% of Indian population. Over and above them, there are 32% of Indian population that is still backward socially and educationally. So if we make a total of 3 categories, SCs, STs and so-called OBCs, that forms almost 60 to 70% of Indian population. And if you don't provide reservation for them, they are never going to be get uplifted. That's the reason what our parliament did was, it made the first amendment in 1951, incorporated clause 4 in article 15 and gave the power to the state, the government, that if you wish, you can provide special treatment, special facility for the weaker sections of the society. Now this is the interesting thing. Constitution says that you can make special provisions for the weaker sections. Who are those weaker sections? Constitution is silent on that. Constitution does not say that it is SCs or STs or OBCs. It just says that it is weaker sections. Who are those weaker sections? Government has to decide. Government might say that women are the weaker section. Okay, you can consider them weaker section and provide some special provision for them. If the state wishes, it can consider even elderly people as the weaker section and provide for some special provision for them. Even children can be considered to be the weaker sections. Handicapped can be considered to be the weaker sections. It has not been defined in the Constitution who are to be considered as the weaker sections. It is the government who has to define that. It is the government who said that for me weaker sections means SCs, STs and OBCs. So if we really want to change the situation of reservation, first we have to go to the government. And moreover, Article 15.4, or for that matter you read clause 4 of Article 16 as well. In both the articles it is written that state shall have the authority to provide for special provision. Mean it is not binding upon you that you have to provide. It is upon your will or your wish. If you want to provide for some special provision, you can. If you don't want, you don't. There is no issue with that. Which kind of special facility? That too you have to decide. If government today decides that for this weaker sections, I want to just open a hostel where they can reside and have good education, good enough, that too is a special provision. Nowhere Constitution mentions that you have to provide reservation in educational institutions. It is the government that has interpreted these provisions in this fashion that has evolved over the period of time reservation system that we are seeing right now. That's the reason I keep on telling my students and everyone that I meet, reservation is never a right, never ever a fundamental right, and that has been endorsed by the Supreme Court as well. It is never a right, never a fundamental right. It is completely upon the will of the state, will of the government. If it wishes that you are going to have reservation, it will give. If it wishes that you do not require reservation, it will not give.
What is you
Shall have authority means you can, or you can say that you may, rather, in the hands of the government. That's it. So union government, whenever it is transacting its business and it finds that these sections of the society are not properly represented in the jobs, you can provide reservation, but Constitution hasn't told you to do the same thing. It is upon your judgment that you are deciding.
Now, how to compare state authorities?
Peripheral groups, civil society like ours, if we ever find that reservation system is not proper, it is not functioning, it is somehow affecting our merit system, it's as simple as that. You can go to the government, appeal before that let's do away with this reservation system. But directly government, I can go to my chief minister, I can go to my prime minister and tell them that, sir, what is the reason that you have continued this system even after 70 years of independence? Give me the reasons. But before appealing before the chief minister or any government of the day, we too must be having quantifiable data.
But nowadays in this era, there are very few state government authorities are the police and complete that. So how to compare them?
But before that, we have to ask ourselves a question. For an example, I completely favor reservation at all the three places because I have quantifiable data for the purpose. Whenever we are opposing or favoring something, we must be having data with us. That if I am opposing that, on what basis I am opposing? Are you getting my point? The way 103rd Amendment was
The
done.
state population, majority people of the state must be in the favor of a particular thing.
Yes.
So if they like, people are in the favor of, majority people are in the favor of a
Date,
particular thing, that happens.
not even in that fashion. Means people would agree to anything said because they don't read, right? So, report,
But you said data, so
data,
about data.
data.
So data comes by the people. It's about the people's opinion, people's choice.
Authentic data. Like while you were making an amendment, 103rd Amendment for EWS, government presented certain reports before the parliament that this is the reason that we are going to give reservation for the economically weaker sections. Economical weaker sections that will not include SCs, STs and OBCs, right? But the reports that they had submitted, you can go through those reports that have been presented before the parliament. Copies of the same are made available on their website as well. All those reports specifically provide that, they mentioned that out of the total poorer population of this country, 80 to 90% belong to SCs, STs and OBCs. So if economic criterion is the one on which you are going to decide economically weaker sections, how come you don't include SCs, STs and OBCs in that EWS category? Are you getting my point? That is the reason 103rd Amendment was challenged before the Supreme Court. Its constitutional validity was challenged. And if you would have noticed that ruling that was passed some 2 weeks ago, all the 5 judges agreed that yes, social and educational backwardness alone cannot be the ground for granting reservation to any community. Economic criterion too can become the ground for the reservation, granting reservation to any community. All 5 judges agreed on that matter. But 2 judges dissented on one matter, that is, whether the SCs, STs and OBCs should be included in the definition of EWS or not. 3 said yes, 3 said they should not be included and majority opinion prevailed. 2 said these should be included, and one of them was our former Chief Justice of India, Justice U. Lalit. That's my point. So the point in making is, debates have to occur in the democracy. You present your view, I would present my view, and out of that, some constructive thing has to come out. That's it. But before that, in order to such healthy debates to take place, first we must be well informed, and that does not happen. At that time also I raised this question on my platforms like YouTube, that after that 103rd Amendment's Supreme Court ruling, every newspaper in our regional media came with the headline that 3 judges are in agreement that economic criterion can be there for reservation, 2 judges disagreed. That was the headline of majority of the newspapers. Even national media reported in the same fashion. That was completely wrong. All 5 judges agreed on one matter, and that is economic criterion as the basis for reservation. What they disagreed upon was a different thing. So if we do not get information correct, how are we going to frame our opinions in a legitimate and rational manner? First, we must be having proper details, right information. Only then we can do a proper debate. And that's what I'm telling, that whenever I am supporting reservation, I do have certain data with me. If you are opposing it, you must do the research, prepare the data, and accordingly put before the government. When it is about political reservation, it is meant for 10 years, that's true. But when it is about reservation in education institutions and public employment, there is no time limit, because it is not compulsory. Yes.
As you mentioned somewhere in a beautiful conversation, it was about the United Kingdom and United States Constitution.
Yes.
So I think 1677 or 1678 you mentioned about United Kingdom.
UK, there happened a glorious revolution. 1688, glorious revolution took place in 1688, and 1689 they had Bill of Rights.
Okay. So sir, like we are, we became in 1949s and 1950s. We are very late in terms of the execution of the Constitution and about the government. You one more thing you mentioned somewhere about the Rangnath committee. Please pardon me about
Justice Verma Committee.
Yeah. So I think 2003 or 2000.
Rangnath Mishra case.
Yes, sir.
Yes.
So, like, when we talk about the constitutions, laws, legislature and all that, only learned people talk about that. Now so far as the new UPA government, they have decided to introduce certain kind of constitutional things in the new education policy. So it's good part of that. So you mentioned somewhere in the world there are only two countries who has implemented or not mentioned about the who are
Fundamental
who are
duties.
mentioned, India and Japan.
Yes.
But apart from that, no country has mentioned. I don't know about the other countries, but I know about the Western countries a little bit. So sir, like they implemented it far before. We are so late.
What I said is their constitution do not have fundamental duties.
Yes, sir.
Ours has.
Yeah.
They do not have.
So the thing is like, it has come in their blood, it has come in their culture.
Yes.
It's there in their education.
For sure. For sure.
If you look at over there, I have been to only two countries in the world, United States.
For sure. Yes.
So like I have seen that teaching model is like, when we want to make an aware,
Yes.
it's very important to have good education system.
Yes.
And good education system comes from the home first.
Yes, for sure.
So sir, so far as the India is concerned, there are so many people. If we talk about the learned people, the ratio is 2 less. I would hardly say that like there are only, on the paper it looks 77% people of the country are
Yes.
learning.
Yes.
But how much they are learning in terms of reading, writing, speaking?
Yes.
So sir, like what do you advocate as an expert of the constitution, how to make aware, grassroots people in terms of the constitution about the law? And majority of the people are misusing that.
Yes.
Because people are not aware.
Yes.
People do not know. Even
Yes.
though, when we talk about downtrodden people, they are not getting their rights.
Yes.
It is already there in the constitution. The people who constituted it, they had a very good, pure holy objective.
Yes.
But somehow it is not reaching the people. So how, as an expert, what are the ways? Why the government has not taken any initiative? Government talks like so many things. I'm not in against of Modi sir. I'm a man of like BJP. But I'm saying that I like him a lot. But so far as the public grassroots awareness is concerned, what are the ways, sir?
In my opinion, what I have seen so far in my career of 12 years, we are always after materialistic gains. When students come to me, their only purpose is getting through the civil services examination and become an IAS officer, IPS officer, if it is about state government, deputy collector or mamlatdar. Nothing more than that. So sir, teach me Constitution of India, only that much which is essential for my examination. Nothing more than that. That happens. And being a professional institute, we have an obligation to serve their needs. Whatever the subject that we teach, be that Indian history, Indian economy, science and technology, be that any subject, we have to teach in such a fashion that is helpful to them for their examinations. That's true. But since I began my teaching in November 2011, I'm not claiming to be a very public spirited person, but I took an initiative that let's make it such an interesting subject that student starts learning this subject with an enthusiasm. He comes to realize that it is not something that is meant for examinations only. It is something which governs my life. It is the constitution which has given me a certain social status, my political existence. So I must be having a little more awareness about that subject rather than other subjects as compared to the other subjects. I did that. I would give you an example. In our field, we have to teach a subject called Indian Polity and Governance that is about mainly Constitution of India. Normally in coaching institutes, even at SPIPA where I used to teach IAS aspirants, for a lecturer it would take hardly some 30 to 40 hours to teach the whole subject. This is Article 15, these are fundamental rights, right to property has been abolished, that thing, that's it. I endeavored, I ventured into it, and today I teach Constitution of India for more than 150 hours. There would be a class of mine where I would be teaching for the whole day for some 8 to 10 hours, and student would not get tired, because I take that responsibility that if he is finding it interesting, I should be speaking, I should be narrating in such a fashion that he does not feel tired. That's my point. Whatever the means that are available to us, for me, it is the platform of civil services examinations, the coaching institute. There I endeavor in such a fashion. My father endeavors in his fashion. Like in 1990s, when I did not have even textbooks of my school, he introduced me to the Constitution of India. I still have that original copy of the Constitution of India. I forgot to bring it here. I always keep it with me wherever I go. So this is how we can develop that culture, that civilization, that we acquaint our kids from the very beginning. I would just narrate one personal event of mine. Yesterday only what we did was, I have two kids. The elder kid is some 5 years old. I made him recite the preamble of the Constitution. We recorded the video. Soon in the evening we are going to upload it on YouTube, just to make masses aware that a child can learn the Constitution. Before Constitution, there has to be constitutionalism. Ambedkar ji always said that constitutionalism precedes Constitution. That population which is not well aware about the constitutionalism, that can never understand what is Constitution. So constitutionalism precedes Constitution. संविधान से पहले आता है संविधानवाद. That's what I am attempting. I made him recite the whole preamble. The same thing I am going to do with my second kid as well. But still he is hardly some 1 year old. I cannot do it now. That's my point. Wherever we go, whatever the platforms we have been given, we can try to talk about the Constitution of India, about the fundamental duties. Everyone talks about the rights. This is my right, that's my right. But no one talks about the duties. Why so? So we have to make them believe that it is your duty as well. If you are claiming it to be right, there is duty as well. Both go hand in hand. And this is how we can develop that culture. When it is about the laws, it is always said that they should not be read. They must not be read only in their letter. They must be read with their spirit. Whenever we read any law, be that IPC, CRPC, or the Supreme Law, Constitution of India itself, we just read the letters. We don't know the spirit behind that. One member of our Constituent Assembly, afterwards he became the member of Parliament as well. After the death of Dr. Bhimrao Ambedkar ji, he famously quoted that Dr. Ambedkar is dead, but his articles are very much alive even today. He said that Dr. B.R. Ambedkar is dead, but his articles are very much alive even today. That's it. So that is the spirit of our Constitution. It teaches us that how you have to run this country. Now it's in our hands. They already framed it some 70 years before. Now it is in our hands that how we are going to run this Constitution. And for that, this is the only option that I think fit. That is, constitutionalism must proceed before Constitution. Whatever the platforms that we have in hand, we must try our best to provide the knowledge of Constitution to the masses. That's it. And with that, we should also take an initiative to spread, to stop the spread of those fake messages, like Article 30A of the Constitution of India. It is something that is not at all written in the Constitution. If something is written in the Constitution and someone misinterprets it, I would educate him, right? And conversation can take place there because he knows something, but it is wrong. I can correct him. But someone comes with a thing that is not at all mentioned in the Constitution. How would I deal with him? So that's where the role of educators, of the learned citizens comes in. If we do this, I certainly believe that the kind of constitutionalism that is prevalent in Western countries, right? Same level we can achieve here as well. There, in my understanding, the people that I know are abroad. They do not need to write in such a fashion or instruct in such a fashion that don't smoke here or pagarkha vyavasthit rakho, barabar se thunku nahi. These are not the kinds of things that everywhere they need to instruct. But here we need to instruct our people.
The reason is that the law are very strict about that. They execute the things.
Yes.
People are aware, they execute the things. Here what happens, we are aware, but we do not execute the things.
Yes.
And so far as the law, this is my personal opinion, maybe I can be wrong. But so far as the law department is concerned, it goes, as you said, somewhere hand by hand. So it's a role of law department as well to
Yes.
implement and execute the laws.
Yeah. And this is the fantastic attempt by you people that you have arranged such a conference or seminar where we can discuss such things. That's an excellent attempt in this regard.
Sir, for the sake of my knowledge, I would like to know one thing from you, if you don't mind. Do you think, are there reservation categories in the abroad Western countries?
Yes, a reservation is everywhere.
Okay.
There is no country in the world which does not have a reservation system in place. Only names are different. If I'm not wrong, in Canada, the same system is known as employment opportunity.
Okay.
In USA, it is known as affirmative action.
So they have a criteria of on the basis of the economical category or the caste category?
That I have studied in that depth, but they have provided for such a system for weaker sections. In USA, the weaker sections are non-white people, right?
In
And
terms of economical capacity, not the caste.
social status,
Social
not economic aspect.
Okay, social status.
There was racism there. It is still there.
Yeah.
Because of racism, the non-white people had to face discrimination. So their social status was very low. Even Abraham Lincoln tried to elevate that as well. You read 13th Amendment of US's Constitution. With that, he abolished slavery. You read 14th Amendment, that is one of the Reconstruction Amendments of US's Constitution. Through that 14th Amendment, they provided for due process of law, equal protection of the laws. And that equal protection of laws, that principle, that doctrine also finds mention in our Constitution and incidentally in Article 14. Equality before the laws and equal protection of the laws. So through 14th Amendment, they made non-white people's status as good as that of the white people. And through 15th Amendment, they gave them right to vote. They were ready to give right to vote to the non-white people, but not to the women. Means the status of women in US's society was lower than even non-white people. Non-white people got their right to vote in 1865. Thereafter, women had to struggle for almost 5 decades. And finally, they got their right in 1920 through 19th Amendment. That's the reality of theirs. Today, they are claiming that we are the best democracy, but this is their history. That's what I pointed out, that in India, women did not have to struggle that way. Are you getting my point? So every country had such a history of social inequality. Economic inequality is everywhere, but social inequality has always formed the basis for granted reservation to any category or any community. So far it has been the norm, but with time, as per the report of S.R. Sinho Commission that was formed in 2006, now we have started considering economic criterion as one of the ground for affirmative action. That's a new thing, a new development. Otherwise, historically, for any affirmative action, social status has always been the ground. That's it. Okay. I always end my seminar, my lecture, with my badge, with all the people wherever I go, with the recitation of preamble. So it's my request that all of us would rise on our places and would recite the preamble once, just to remember those ideals, those noble ideals that have made us a nation. We are surviving as a nation. It is just because of these ideals that have been enshrined in our preamble. I would speak first, you speak later, whatever I speak. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring dignity of individual and unity and integrity of nation. In our constant assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you. Namaste.